This is Chapter 18 and 19 summaries. So Chapter 18 talks about the law of administrative agencies. This focuses on administrative law, which is any rule that directly or indirectly affects an administrative agency. There's a procedural rule, which is a rule that governs the internal processes of an administrative agency. And then there's the substantive rule, which is a rule that creates, defines, or regulates the legal rights of administrative agencies and the parties they regulate. Some administrative agencies include independent agencies and executive agencies. Administrative agencies have grown because of their flexibility, their need for expertise, the prevention of overcrowding in courts, and the expeditious solutions to national problems. Some functions of administrative agencies, there's rulemaking, which has 5 steps, and these steps include step 1, which is an agency drafts rules in consultation with interested parties. Then step 2, the proposed rules are published in the Federal Register. Step 3, interested parties can file written comments on the written draft, usually within a 30-day period. Step 4, the final draft of a rule is published in the Federal Register 30 days before it takes effect. Then step 5 is the agency receives feedback from interested parties during the 30-day period and makes a decision on whether the final draft should be written. There are some limitations on the administrative agency's powers. This is statutory limitations and institutional limitations. Chapter 19 talks about the employment relationship and immigration laws. It talks about wage and hour laws, so this includes like minimum wage and having to pay your workers a certain amount, and then mandatory breaks with the numbers depending on the number of hours you've worked. And then unemployment compensation. So the Tax Act created a system providing unemployment compensation to qualified employees who lose their jobs. Workers' compensation laws is a state law that provides financial compensation to covered employees or their dependents when employees are injured on the job. Then there's the Family and Medical Leave Act of 1993. It's a law that designed to guarantee that workers facing a medical catastrophe or certain specified family responsibilities will be able to take the needed time off from work without pay, but without losing their medical benefits. So this is often women have maternity leave when they are pregnant or have their child. And then it goes on to talk about Occupational Safety and Health Act, or OSHA. So the OSH Act is a regulatory act designed to provide a workplace free from recognized hazards that are likely to cause death or serious harm to employees. And then OSHA is the agency responsible for enforcing that rule. Then it talked about immigration law. So the Immigration Reform and Control Act of 1986 stated that employees can only hire people who can legally work in the U.S. There are some exceptions, which is authorized non-citizen workers who are workers on a permit. These permits are either permanent or temporary, and we often refer to them as green cards.